Welcome, everybody. My name is Lisa Rodriguez, and I am the Director of Retail National Accounts here at NewView. Today's webinar is going to be about land trust, foreclosures, and evictions from a legal perspective. So I do want to confess that we are not attorneys, CPAs, or financial advisors. We are non-fiduciary, so although most of our clients' questions are pretty black and white, we do sometimes get into a gray area. We do have very creative clients, so we do refer those back to their attorneys, CPAs, and financial advisors. Where does NewView Trust fit in? So we are a custodian. We are similar to a bank in that we hold your funds until you tell us where to direct those. So we also believe in three uniques. We want to make our processes simple here at NewView for you. We want to make sure that we're available. So much so we are an essential business and we are up and running during COVID, and we are taking our precautions seriously. But we do want to make sure that we are available here for our clients. And also we want to be very responsive to your needs. We understand that a lot of transactions are urgent, and we want to make sure that we earn the responsibility, the relationship with you through our business. So I would like to take this time to introduce Kim Soto. She is going to be speaking today on the webinar, and she received her bachelor's degree in 2008 at Rollins College, and that was magna cum laude. So she also graduated with her Juris Doctorate in 2011 at George Washington University Law School. Her experience includes representing buyers and sellers in residential real estate transactions, also landlords in lease negotiations and evictions, and then lastly, investors in purchasing and sales of hotels, apartment buildings, and condos. So without further ado, I will introduce Kimberly Soto.
Hi, everyone. So today we're going to talk about some foreclosures, evictions, some unique challenges in today's world. So I hope everyone is staying safe and healthy. I'm really excited that you're able to join us today, and hopefully we can answer some of your questions. We're also going to talk about some land trust at the end. Okay, so the first thing I wanted to touch base with is foreclosure. So kind of before we get into the nitty-gritty of the foreclosure world, I want to back up and talk a little bit about how to protect yourself as a lender before you even have to think about foreclosing or contacting an attorney. And so what you want to think about is when you're talking with a borrower and you're thinking about lending someone money to purchase a property, you definitely want to make sure that the borrower is going to sign both a note and a mortgage. So the note is going to be what actually is the promise for them to pay you back. The note's going to have, what the amount that you're lending is, what the terms are, like the interest rate, whether it's going to be a balloon mortgage, how often the payments are due, when they're due. So the note is definitely a very important document to have. The second document that you want them to sign is the actual mortgage. And the mortgage is going to be what secures your investment in the property so that you become a secured lender. And so that the property itself is what basically is your insurance in case they don't pay. So once you have both of those documents signed, then you want to record the mortgage. And it's really important to make sure that you record the mortgage in the correct county. And so you want to record the mortgage in the county where the property is located. So you look at not where the borrower lives, not where you live, but where the actual house or land or condominium is located. You want to record the mortgage in that county. And you also really want to make sure that the legal description is correct on the mortgage itself. There are a couple ways to pull the legal description, but the best way is to actually have a title company or an attorney who has an underwriter actually order like a title commitment or a title search so that you make sure to actually get the full legal description. One way to pull legal is to actually go to the property appraiser for the county where the property is located and look at past deeds that have been recorded. The only concerns that there are with doing that is that sometimes For example, when the county sells the property at a tax deed sale, they use a shortened version of the legal. So it's not always the best description to use. And then if you are pulling deeds that were not done by title companies or were not done by attorneys, like a lot of quitclaim deeds that are pulled offline that people draft themselves, they could actually have the incorrect legal description. So they could list the wrong lot number, the wrong book and page. So you just want to make sure that the legal description is correct on your mortgage. If you're lending to a borrower who is a corporation or an LLC, and that isn't a person, you want to make sure that the borrower also signs a personal guarantee. So that's just an added layer of protection for you. If the borrower or the personal guarantor has a spouse, you also want to consider having them sign the note and mortgage or having them sign a separate personal guarantee. So these are things that are, usually case specific, depending on who's going to actually be the borrower, who's going to sign the documents. So it's definitely good to have an attorney look over what you want your deal to be to make sure that you're crossing all of your T's and dotting all of your I's to help protect yourself. Another thing that's really important is if you are lending money on a property, you want to make sure that you're in first position. And if you're not in first position, you want to understand what that means. So the way to determine whether you're in first position is you can either order a lien search or a title commitment on the property, and you can do that through an attorney who has an underwriter or through a title company. And that search will come back and tell you what, if any, liens have already attached to the property. So those will tell you whether there's already a mortgage. And so if there's already a mortgage, you might not want to lend more money. Whether there's an IRS tax lien, whether the real estate taxes haven't been paid. There could be judgments in the name of the homeowner that have attached to the property. So you just want to make sure that either the borrower clears all of those liens that have attached, or you want to understand what not being in first position means. Another thing to take into account is that you can do your own lien searches, but definitely make sure that you know what you're doing and you understand how to fully search for everything, because all liens are going to be recorded in the public records, but you want to make sure that you understand the different nuances to searching if you're going to do it yourself. Another consideration that you want to think about is making sure that there's enough equity in the property. Because when you are first starting these deals, everyone hopes that it's going to go very smoothly and that the borrower is going to be able to pay under the terms of the note and the mortgage. If it's a balloon mortgage, they'll be able to refinance and pay off. But the reality is that in life, things are uncertain, as we kind of are all learning from a front row seat. And so you want to make sure that you start the deal with enough equity that if 2, 3, 6 months down the line, the borrower stops paying, do you have enough equity in the property to start a foreclosure process and be able to recover your fees and costs? And then you also don't want to forget about bankruptcy. So while foreclosures can be fairly simple and straightforward, at any point during the foreclosure process, even up to the day of a foreclosure sale, as long as the borrower does it early enough, they can file bankruptcy. What that does is bankruptcy is in the federal court system. And so the foreclosures are in the state court system. And federal always trumps state. So once a bankruptcy has been filed, there's an automatic stay that goes into effect. So the sale will be canceled. And if it's not canceled, it will be vacated until the bankruptcy is dealt with. And a couple ways from the lender perspective, to deal with the bankruptcy is to wait until the case is either dismissed or discharged, file a motion for relief from the stay, and what that does is that lets the judge in the bankruptcy court know, hey, I have a foreclosure going on, the borrower hasn't paid, I'm not going to go after them personally, but I do want to foreclose on the property so that it can be set for sale so that I can be made whole again. And so those are kind of standard procedures and things that we can do in the bankruptcy case to help move you forward. But definitely, think about bankruptcy if you're ever, thinking about the possibility of having to foreclose in the future. so that was kind of a summary of foreclosure. So now we're going to talk about evictions. Okay, so some of the times when you're going to file an eviction, there are usually two different situations. One, either the tenant is not paying you the rent that they owe you, or they're not following a non-monetary provision of the lease. So some common non-monetary violations are the tenant's failure to provide proof of rental insurance. You do actually have to have these terms in the lease agreement between you and the tenant to enforce them. So if you do not have a provision that the tenant needs to have rental insurance and provide you with a copy of it, then you won't be able to evict for their failure to do that. So you definitely want to, from the very beginning, make sure that your lease includes all of the important terms between you and the tenant, and what's important to you, what you want them to do, the things that you want them to follow. So a common one is failure to provide rental insurance. Another one is the tenant allowing someone or multiple people to live in the property who aren't on the lease. So most standard leases will list all adults that are living in the property. One of the difficult things is trying to prove whether someone else is living in the property as opposed to visiting. So what you can do in your lease is you can say that they are allowed to have guests, but for no more than 7 overnights in the same month, for no more than 3 consecutive overnights in a row without prior approval from you. So there are definitely ways to help protect you and make it a little bit easier to prove if someone really has moved in and is now living rent-free in your property. So another common non-monetary violation is if someone is not allowed to have pets or only allowed to have a certain number. And so they either now have pets when they're not allowed to, or they've moved in a few extra dogs or cats. So those are some common non-monetary violations. And so if a tenant is not paying rent or isn't following another provision of the lease, the owner can evict them. And so when we talk about who the owner is, we look at who the title owner is. So who is the owner of the property, and that's going to be who the plaintiff is. And so before you can file an eviction, Florida statute has what we call pre-suit notices. So these are things that the landlord must do before filing an eviction, or the eviction will be improper. So if the tenant is not paying rent, the landlord has to serve a 3-day notice on the tenant. That gives the tenant 3 days to basically fix the violation. The violation in this case is they haven't paid rent, so now they have 3 days to pay rent. One thing that you really have to remember with 3-day notices is how you count the days. So if I serve someone a notice today, it's Thursday. Today does not count. So I can't count today as one of the 3 days. My day starts tomorrow, and tomorrow's Friday, and so that will be day 1. And then some people might want to think Saturday and Sunday then become day 2 and 3, but that is not the case. Florida statute specifically excludes weekends and federal holidays. So if I serve a 3-day notice today, the tenant actually has Friday, which is day 1, Saturday, Sunday don't count, Monday is day 2, and Tuesday is day 3. So they actually have from now until Tuesday to pay the rent. That timeline is where a lot of landlords who do the notices themselves can get tripped up. So just really make sure if you're doing the notice yourself instead of hiring an attorney that you're counting the days correctly. Now that's a 3-day notice for non-payment of rent. If the tenant is violating some other provision of the lease, you have to send them a 7-day notice. And so the 7-day notice allows them 7 days to cure whatever the violation is. So either move out the pets, move out the people living in the property who aren't on the lease, or provide a new proof of rental insurance. So they have 7 days to do that. During these notice periods, whether it's a 3-day or a 7-day, if the tenant cures the violation, then that ends the process. Florida statute says that landlords, you can give them the notice, but tenants, you have the opportunity to cure. So once it's cured until the next violation. But assuming that the tenant does not cure the violation, then the landlord can file a complaint for eviction. the clerk will issue the summons, which are served on the tenant. For evictions, tenants actually only have 5 days to respond. So it is a very quick turnaround. Normal lawsuits, defendants have 20 days to respond. So Florida statute, they really are trying to make eviction summary proceedings and cut down on the timeline. If you're filing an eviction for a monetary violation, meaning the tenant hasn't paid their rent, the tenant has to pay the rent into the court registry, otherwise they are going to be evicted. So that's something that a lot of tenants don't realize. They think, oh, the process is going to take a while, I can fight it, but they actually will have to pay rent into the court registry. The only time that they don't have to pay rent into the court registry is if they have an excuse, meaning that they've already paid the rent. If they have proof that they submitted payment to the landlord, maybe they did a direct deposit and they actually paid the rent, the landlord may have missed it, or the property management company didn't communicate with the landlord. So payment of rent is definitely a defense to eviction if they've actually paid it. So now we're going to talk about some special considerations. I know that this is a unique time. This is the first time we're really dealing with the pandemic, and so there has been a lot of confusion, a lot of orders being signed, by the Supreme Court of the country, by Florida, by the governors. There's a lot going on. So for right now, hopefully everyone was fairly okay for April, meaning your borrowers and your tenants made payments for their April 1st payments. Hopefully, we were kind of close enough at the end of March that April has either been resolved by you receiving payment or you've already gotten in touch with your borrower or tenants about the situation. Because we're still in a stay-at-home order, you definitely want to look to, what's going to happen in May. Are people out of work? Have they, received unemployment? Have they received their stimulus checks? You really want to start now, in middle of April. Reach out to your borrowers and tenants. See how they're doing. Check in on them. See financially, do they think that they're going to be okay? Do they think that they'll be able to cover May's payment? Or do you want to get a plan in place now that either maybe partially defers the payment, gets them on a payment plan, adds it into the end of the lease or the mortgage? The best thing to do, though, is reach out now because you don't want to be blindsided come May 1st. So our governor signed an order on April 2nd of this year. And what that order basically did is it suspended foreclosures and evictions for 45 days from the date of the order. That he could enter another order extending it. We're not sure whether those 45 days is truly going to be the end and whether it's going to be lifted for foreclosures and evictions proceedings. So what that means, though, in daily life and on the practical side is that if you have a borrower who is not paying their mortgage, you can still send them a default notice. So usually the default notice is going to be a notice to the borrower that states, they haven't paid rent they haven't paid their mortgage for X number of months, the total amount that would be due to cure the default, so paying all of those months that are owed, and then also an acceleration clause that states that if they don't pay by the notice expiration date, that you're going to accelerate the mortgage, meaning that the total amount will be due immediately. So you can still send your default notices. For tenants, you can still send the pre-suit notices. So the 3-day notice and the 7-day notice, you can still send those so that you kind of start the clock ticking and have already started the process. You can also file the case. So we are now on an e-filing system, and so every attorney has a login, and so I simply upload my cases and my documents via the Florida e-filing portal. So it's something that I can do from home, I can do from the office. We've really come to, a very much remote world in terms of filing with the court. So I can go ahead and file the complaint either for foreclosure or for eviction with the clerk. Now it's when it gets a little tricky. And this is going to be a county by county determination. and also a judge-by-judge determination. So once the case is filed, the requirements on me to file are the complaint with all of the exhibits, and then also the summons. So in some counties, for residential foreclosures and for evictions, the clerk will not issue the summons. They will simply stop the case at that point until the order is lifted. So 45 days from April 2nd is when they can start issuing the summons. And so that is a county by county rule that they are implementing. If it's in a county where maybe before April 2nd, the eviction process was started, or if it's a county where they are going to issue the summons, and so you can start that process, it's a judge-by-judge determination as to whether they will hold a final hearing or sign a final order of eviction. So that is dependent on the judges. Some of them will simply not have the hearings or will not sign the orders until the 45 days have passed. If you are in a county where you have filed the complaint, gotten the summons, everyone has been served, and you've gotten that final order of either a eviction or foreclosure, and the clerk has issued a writ of possession, the sheriff will not execute the writ of possession. So what that means is the sheriff will not actually go to the property and remove anyone from the house until the 45 days are over. You know, the rationale behind it is we're trying to keep people at home. So we don't want to be evicting or removing people from the house who don't have anywhere to go. So that's kind of the rationale behind it. And so that's just the practical aspects that you're looking at. The order specifically states that this does not excuse anyone from not paying their rent or mortgage. But, you know, if they can't afford it and you can't evict, you can be in a very tight situation. So that's why I definitely recommend reach out to your borrowers and tenants now. Because like I said, we can always file the case. And so having a foreclosure or an eviction on their record will hopefully be enough leverage for you to be able to come to some type of an agreement. So now we're going to switch gears and talk a little bit about land trusts. So land trusts are one mechanism that you can use to take title to a property. One of the benefits to a land trust is privacy. So trust documents in Florida are not recorded, ever. They're not recorded in the public records. It's simply something that is not required and does not happen. So it's very different from a mortgage in that sense. So what will show up in the public records is if I'm purchasing a property and I would like to purchase it in a land trust, the way that the deed will appear is the owner will be XYZ company as trustee of ABC Trust. And so the trustee name will appear and the name of the trust itself will appear, but no other information. So that's how you can have some privacy, because your name, so my name, Kimberly Soto, doesn't actually appear in the public records. One consideration, though, is that if I already own a property and I'm going to transfer it into a land trust, a SWABI attorney or someone who is familiar with collections and familiar with real estate law and how transfers work can probably guess pretty quickly and easily that if I owned a piece of property and then I transferred it into XYZ trustee, you know, of XYZ land trust, and I only paid the $10, you know, consideration and the $70 doc stamps, that I can, you know, pretty securely assume that I'm going to still be the beneficiary of it. So that's just something to think about, that usually land trusts, they're going to come in when you're purchasing the property. You can certainly transfer a property into them at a later time, but because you've already purchased the property in your personal name, you're going to show up in the chain of title. So land trust can be very useful because it's a very easy transfer of beneficial interest. So it's an amendment to the trust, and once again, that amendment is not recorded in the public records. If the land trusts are set up correctly, it can also avoid probate. So you can list, you know, the first beneficiary as a natural person, and then who the second beneficiary is. What happens to the property if that person passes away? Now, if the first beneficiary is a corporation, then this won't apply because corporations can't die. So the way that the land trust documents are set up is that it literally states that if the first beneficiary passes away, then their interest is going to be transferred to Joe. But with a corporation, corporations don't die. They may be dissolved, but they don't ever die. And so when you have a corporation who's going to be the beneficial interest owner, you're going to want to look to the operating agreement and who the actual owners of the company is, and see whether they're a natural person or whether they actually have an estate planning trust that is set up that would then avoid probate. So you're always going to want to be looking at the operating agreement in conjunction with that person's estate planning document. So a very large benefit to land trusts are that code violations attach if the owner is the same. So if you have a separate land trust for each property that you own, then the code violations won't attach to each other. And so that won't infringe on your ability to sell a property. One of the cons to a land trust is that because one of the main purposes of a land trust is privacy and also to have the owner names be different between the properties, is that you use a third-party trustee. So you can either use an attorney, like a law firm, or there are third-party trustees that you can use, but they do charge a fee. And land trusts cannot be used to circumvent the foreclosure process. So years ago, during the foreclosure heyday back in 2009, 2010, there were some people who were setting up land trusts where the lender was the first beneficiary, and if the borrower didn't pay, they simply removed the borrower from the land trust documents. The appellate courts came down very hard against that. You cannot use a land trust as the purpose to circumvent a foreclosure. We are a judicial foreclosure state, and so the courts did not like that. People were trying to kind of skip the foreclosure process and ease around it to make it easier for the lenders. So that's just something to keep in mind, that you can definitely get hit with it not being an appropriate foreclosure, and so then you can be violating someone's due process rights. So now some things to think about going forward. So we've been in a seller's market for a long time, and so we are most likely in the process of transitioning to a buyer's market. Depending on how long this pandemic affects us and affects us economically and financially, there is most likely going to be a new wave of foreclosures. And so those are sold by the county online. And so some things to think about when you are looking to purchase properties as your investment. When you go on the county's website or the auction website to view foreclosures, all foreclosures are lumped together. So the first mortgage, the second mortgage, HOA and condo association foreclosures, they are all listed together. And the documents don't necessarily need to say that this is a first mortgage or a second mortgage. So you really want to be careful and actually look at, if you see a property that's going to foreclosure sale that you're interested in, you actually want to go back and view the case. You want to go to the clerk's website, pull up the docket, and actually see what's happened in this case. You want to look at the complaint, see who filed it. If the plaintiff is a homeowners association or a condo association, then that means that the property is not necessarily free and clear. In an HOA or condo foreclosure, they cannot name superior lien holders. So if there is a first mortgage or a second mortgage on the property, they cannot name them in the foreclosure because they cannot wipe them out because they're superior. So they won't be named. So usually the associations will only name the homeowners, maybe their spouses, unknown tenants, but they won't actually name a mortgage. And so if you're purchasing a property from an HOA or COA sale and you think, okay, you got a great property, you only had to pay $20,000 for it, well, double check to make sure that the first mortgage isn't coming down the line and has a sale set next month. When you purchase these properties online, there are a ton of disclaimers. It warns you that these are as-is sales. You are taking these at your own risk. Buyer beware. Because you used funds to purchase a property that has no equity in it because it has a superior mortgage, those are not grounds to get your money back from the sale that you purchased. So just make sure that when you're purchasing, you understand what foreclosure you're purchasing from. And so with, hopefully, all of these new potential buying opportunities in the future, you want to consider using your IRA to do it going forward. And so I definitely suggest, if you haven't already, go ahead and get an account set up with NewView today, because these deals, once they start coming in, they're going to go very quickly. So you definitely want to make sure that you're in a position to be able to purchase properties and get in on these deals, and definitely have a stream of income coming in. And so that's kind of it for the presentation today. So I just wanted to kind of very briefly go over some other services that my firm offers. So we also offer legal guidance in estate planning, family law, guardianship, immigration, of course, real estate law, and civil litigation. And so then at this point, I think that we will open it up to some questions. Okay, so the first question we have is, will I share these slides in an email after the webinar? If you can see your screen right now, you have my email address. If you will go ahead and shoot me an email, then I can certainly forward you the slides so that you can always look back at them and see what questions you have, or to refresh your memory. So go ahead and send me an email, just a request for the slides from today's presentation. And then the second question that we have is, wouldn't the signature of the leasing agent be the authority to file an eviction? And so that question is kind of a couple-fold. So you can have your leasing agent go ahead and file for the eviction. So there are a couple of different ways that it can be done. Either you can actually grant them a limited power of attorney, which would be separate from the lease, or you would have a leasing agreement with the leasing agent, and they have the authority as manager to act on your behalf for the eviction proceeding. So yes, your leasing agent absolutely can handle the evictions and work with an attorney on your behalf. Okay, so a third question we have is, can you include the late fees in the total due in the default letter or 3-day notice for eviction? This is a great question. So you have to be really careful when you put the amounts that you're alleging you're owed in a 3-day notice. So under a case law, you can only put rent. But a caveat is that as long as in your lease you have the special language that basically states any late fees, interest, or additional costs or fees incurred will be treated as rent and collected in the same manner as rent, then you can add those into the 3-day notice. So you have to look at your lease language to determine whether you can add them in or not. If you're not working with an attorney, you might want to be careful, because you have to have that language in your lease, and if you don't, then your 3-day notice is going to be invalid. So you really want to look and determine, okay, how much is the late fee? If it's a nominal amount, if it's $50 and they're behind by 2 months, you might just not want to include that so that you don't ever have to have a potential issue later. But that is an individual lease by lease determination that you'll be making. So one of the questions we have is, do I do land trust? So yes, my law firm drafts and create land trust. So if you have any questions on foreclosures, evictions, or land trust, you can certainly reach out to us, and we can definitely get you set up with land trust or any documents that you need. We work with a lot of investors, so we're very privy to the kind of unique situations that investors face. Okay, so one question that we have is, if your corporation has the beneficial interest of a property owned in a land trust, the owners of the corporation are individuals, how do you amend the operating agreement to avoid probate? So this is kind of a two-part question. So what you want to do is you want to look at the operating agreement and see whether it even has a provision for what happens if one of the partners passes away. So if an owner passes away, what actually happens to their interest in the company? Does it go to their spouse? Does it revert back to the other owners of the company? You want to find out what the operating agreement says. You, though, have to do a second step. And so then you want to amend the operating agreement to make sure that the shares will pass how you deem that they should. You have to do a second step, though, and also to avoid probate, you actually have to, instead of owning the company in your personal name, you want to own it as trustee of your own personal estate planning trust. Because if a trust owns the shares or interest in the company, then that can avoid probate, and the trustee will actually be the entity that transfers the beneficial interest of the company to your next of kin. So that's a kind of a two-part answer, is that you want to look at the operating agreement and probably amend it, and then you also need to look into your own estate planning. Okay, so we have a question. In certain parts of the country, I have noticed that the preponderance of homes are held through family trust. What is the benefit of this, and can it be done when there is a mortgage needed at the time of purchase? This is a great question. Okay, so family trusts are an estate planning tool that can be used. So the benefit to owning a home in a trust or a family trust instead of your own personal name is to avoid probate. So right now, me and my husband own our property. So the way that we're listed on title is it's Kimberly Soto and Matthew Anderson as husband and wife. When one of us passes away, if I pass away, we just record my death certificate and my interest in the property will automatically pass to my husband, Matt. But once Matt passes away, since he owns the whole property in his personal name, there will have to be a probate opened, and then the probate will determine who the property goes to. If instead of us owning it in our personal name now, if we transfer title into a family trust so that we own it, Kimberly Soto and Matthew Anderson, as co-trustees of the Soto Family Trust of 2020, that should avoid probate. So what happens when we pass away is our heirs will actually look to our trust document. We would select someone to serve as successor trustee, and that successor trustee will follow whatever we've said in our trust. So if we tell them to hold on to the property because we have 2 minor children, and so we want them to maybe rent out the property and use those proceeds for the benefit of our children. If we have adult children, we maybe tell the trustee, okay, go ahead and sell the property and disperse the proceeds equally among our adult children. So your family trust will avoid probate, and it is what will tell your successor trustee what will happen to your property. And so that's the benefit of a family trust. It avoids probate. And so now if you have a mortgage on your property, you can still transfer your interest into a family trust. As long as the beneficial interest doesn't transfer, the acceleration clause will not kick in. So that's actually a federal rule that protects everyone. So me and Matt, we have a mortgage on our property. If we sign a quitclaim deed from us to our trust, because we are the ones who own the property and we're going to be the first and only beneficiaries under our family trust, ownership, equitable ownership hasn't changed, and so we will not trigger the acceleration clause. Okay, so does the current state of eviction rules apply to business tenants? Great question. It does not. So the carve out was for residential evictions, not commercial evictions. Oh, this is a great question. So the question is, if the tenant has sent the keys after moving out by mail, and I have not received the mail and the keys, then does the tenant still have possession of the property or not? That's a great question and will really depend on the circumstances. If you have been in touch with the tenant and they have notified you that they did send the mail, that they have secured the property and they have left the property, then you can go ahead and go to the property, check out whether they have any of their belongings left there, and if they don't, then you can go ahead and take possession of the property. If, though, it's a tenant who is maybe trying to trick you, who knows some of the rules and says, oh, I put them in the mail, but maybe they actually weren't put in the mail, you haven't received them, you go to the property and there's still some of their belongings left behind, then you would still want to move forward with the eviction process. If you can't reach out to them to, resolve it with the tenant, you would actually want to move through the eviction process to make sure that you take possession of the property appropriately and legally. So are there any mandatory relief that will prevent eviction due to COVID-19? And if so, what are the terms? That's something that we already discussed, but basically on April 2nd, there is a 45-day hold on residential evictions and residential foreclosures. So we have a question. The tenant has until May 18th before eviction can be started. So I think we already kind of covered that in our previous slide, but basically there is an order signed April 2nd holding residential evictions for 45 days, but depending on what you can actually do in the process depends county by county. So you can always serve them the notices and file the complaint. Some counties will still issue the summons, some judges will still issue final judgments, but across all counties, the sheriffs will not execute the writ of possession. So they will not go to the property and actually remove the tenant from the home. So that is kind of a shortened version of the long answer that I gave earlier. So we have, do we have a CPA within the law firm to do taxes? No, we don't, but we do partner with a lot of CPAs, various different ones, some of them who specifically work with real estate investors. So we can always offer referrals for a CPA or for someone to do taxes. So we have a question. Is there a way to expedite the sheriff to evict the tenant quickly? So under Florida statute, evictions are what we call summary proceedings. So they are supposed to happen very quickly. The reality is, though, outside of the time that we're living in, you're really looking at 4 to 6 weeks for a full eviction. And that's starting from the day that you give notice to when the tenant actually removes them from the property. The reason for that is there are steps that have to be followed. So sometimes, you can get evictions done in 2 weeks. Sometimes they take 6 weeks or more. It really does depend on whether the tenant is fighting the foreclosure, what defenses they've raised, and also what county you're filing in, what processes they have in place to ensure that evictions move quickly and seamlessly. How quickly is the clerk issuing summons? How quickly are they issuing writs? How quickly is the sheriff executing a writ once they receive it? So that really does kind of depend county by county. And of course now, there is no way to expedite them. So we are in a holding pattern for the last step of eviction. We have a question, is this available on NewView website later? Missed most of it. I believe it will be. This is being recorded, so you can always check back and view the recording. So we have a question. What do you suggest if the tenant is not communicating and is a few months behind in the current situation? So that is unfortunately a tricky situation. So if they are not communicating with you, then you can start the eviction process. Go ahead and serve them with the 3-day notice. Hopefully that will get them to at least communicate with you. And if not, at least you've already started the clock running. So you can go ahead and serve them with the 3-day notice. If they don't satisfy it, you can go ahead and file the eviction complaint. And like I said, it's going to depend on county by county, whether you at this point can take next steps or not. But doing the 3-day notice and filing the complaint, it at least gets you started, and also will maybe kind of jar the tenant out of the fact that they aren't communicating with you, and will hopefully open up that dialogue that is so necessary right now. So we got, is my firm authorized to do foreclosure proceedings in the state of Mississippi? So we are not. I am licensed in Florida, so I can handle any Florida matter that is at the state level. And then, of course, if it's a federal matter like bankruptcy, we can handle that as well. But I am not licensed, and no one in my firm is licensed in any other state but Florida. But we can assist you with any of your needs in Florida, regardless of what county they're located in. So the benefit of being licensed in Florida is I'm able to practice in every county. Since a lot of the foreclosure and eviction work that we do doesn't necessarily require an in-person hearing. So we've handled cases in Marion County, Okeechobee, Broward. We can really handle a lot of counties, and it's not going to hit your pocketbook because we're not going to be charging you for a 3-hour drive time. So there's a lot of tools that we can use, thankfully, especially in this day and age. So we have questions. So the foreclosure order applies to owner-occupied as well as commercial company-owned borrowers. No, so far the order applies to residential foreclosures. So it does not apply to commercial borrowers. So if you have a commercial borrower, you can still move forward with your evictions and foreclosures. Okay, so we have a question. What is the quickest, shortest way to get the property back in Florida? So that's going to depend on whether it's a foreclosure or an eviction. Unfortunately, there is not going to be a quick, short way. The best way to do it is to make sure that from the beginning, your documents and contracts are very ironclad. So you want to make sure that if you are lending money, that your note and mortgage are very protective, in meaning that they protect you and they protect your rights and what your ability has to do. For an eviction, same thing with a lease. You want to make sure that your lease has been drafted and reviewed by an attorney. Make sure that you crossed all your T's and dotted all your I's. The problem is that Florida is a judicial foreclosure and eviction state. So there is no way around that. In order to get a property back, whether you have a tenant in it who's not paying or a borrower who's not paying, you have to go through the legal system. We, have very strict requirements for due process. So there are notice requirements that you have to meet. The borrower or tenant, they have the right to bring up their defenses. Whether they are legitimate or not, they have the right to present them. So there definitely are a lot of tools that we can use. There's a lot of case law, a lot of Florida statutes that really are beneficial for borrowers and landlords. But there unfortunately is no quick and short way. And so that's why whenever you're doing these deals, you want to make sure that for a tenant, do you have enough of a security deposit in case you have to evict? Have you really done your due diligence of making sure they'll be a good tenant? For borrowers, is there enough equity in the property that if you have to foreclose, you won't be eating your attorney's fees and costs for a foreclosure and potential bankruptcy? So really it's making sure that when you go into these deals at the beginning, you're really thinking of these scenarios. So how much time does the landlord have to return the security deposit back to the tenant? So if you are not, as a landlord, if you're not going to make a claim on the security deposit, you have 15 days from when they move out to return the security deposit to the tenant. If you're going to make a claim on the security deposit, you have 30 days to make that claim. So that really just depends on the situation. Once you've made a claim against the security deposit, the tenant has the option to basically object to that claim. So that really just kind of depends on the timeline of the specific situation. Oh, this is a good question. Can we file for evictions electronically as well, or is this only available for attorneys? So my understanding is that you actually can contact the clerk and have your own e-portal filing capability set up. I'm not very familiar with it, so I know, as an attorney, we each have a login, but I do know that pro se parties, so parties who aren't attorneys, do have the ability to set up an e-portal electronic filing system. What you want to keep in mind, though, is that when you e-file documents, those are going to be served. So a copy is going to be sent to the clerk, and then a copy is going to be sent to any other party on the e-service list. If, though, you're, for example, filing an eviction and your tenant does not have a login, is not on the e-service portal, you're going to still have to, mail them copies of everything you file. Florida, like I said, is very strict about due process. Everyone in a case must be notified and receive copies of everything that is happening. So that's just something to really remember, that if you're going to take advantage of the e-filing portal, people who are involved in the case who are not on the e-filing portal must get copies of whatever you're filing as well. Okay, so we have a kind of long, convoluted question. So it says, I have an agreement for sale with the folks which converts to a month-to-month lease after 6 months. If they do not close and convert to mortgage and note, can I still evict once 6 months are passed and they are not closed to convert to mortgage, or do I still have to do a foreclosure? This is a great question and also a very, very fact-specific question. So it's going to depend on what your agreement states. So what this is, it sounds like you entered into an agreement for sale, but that if it doesn't close within 6 months, then it's going to convert to a landlord-tenant situation where you're going to have a lease. So I'm assuming that the lease terms are already incorporated. And so as long as the agreement was done correctly, once the 6 months has passed, they are no longer a purchaser. They become solely a tenant, and therefore you would be able to file an eviction. And I think that we are running out of time, so I know that NewView has a few more points that they want to let you know about. But thank you so much for joining us today, and I've really appreciated all these thoughtful questions. And like I said, feel free to reach out for any of your legal needs, and we'll be sure to help you.
Thank you so much, Kimberly. We appreciate your time. We also appreciate everyone that was on the call, and we appreciate your time as well. I know there were some questions in regards to NewView accounts and some fees, so I will take those as a one-off and get back with you. But if you would like, you could see that my direct phone number is on this slide, so if you want to take a screenshot of that, it's 407-412-7177, and we would be happy to assist you. Again, thank you, everyone, and have a great day.